And Andrew, let me just go to your reading of the judge's order here, which in my reading included almost the encouragement that they bring this issue up again.
This was the worst possible outcome for the government, because if the judge had simply said, I agree with Donald Trump and I find that this is vague and I'm dismissing it, the government could have appealed it to the 11th Circuit, as they have done twice before and won twice before. And that is something that this judge is trying to avoid at all cost. But she also did not want to rule in favor of the government. So what she did is said, you know what, why don't you bring this up later? I think there's some real issues here. And so she sort of flagged that. And there will be a lot of complications if she deals with this after a jury is sworn in this case, because that is the key moment where double jeopardy attaches, and there are various legal consequences to that. So this is the worst possible decision for the government. And by kicking it down the road and saying, but I still may decide in Donald Trump's favor later, she has sort of avoided the sort of Damocles of the 11th Circuit, but she has not given the government what they clearly, as you pointed out, deserve, because there is nothing vague about the statute. People are in jail all over, as Bradley knows, for violating this statute.
Neal, your reading of what happened in that courtroom today and the ensuing judgment.
Yeah, I think Andrew is basically right that, there were definitely, I think, much better outcomes for the government, including even possibly just a straight loss that would allow them to take the appeal. But on the other hand, the Judge Cannon did basically suggest that this isn't vague, or at least not vague enough at this moment in time. Now, that is a win for the government, but it is only a temporary win and not a huge one. And my fear, Lawrence, is that this is going to be a win for Jack Smith in the same way as like the win will be once the Supreme Court decides the absolute immunity case that they're hearing on April 25th. I think there's no chance the United States Supreme Court is going to side with Trump on absolute immunity. But the court, by having such a delayed schedule, gave Donald Trump what he wants, which is a very realistic possibility he can delay the case past the election. That's basically what Cannon has done here, too, kicking the can down the road. I mean, Lawrence, she had a full day hearing about these two legal issues, which were thoroughly absurd. I mean, really, the only thing Donald Trump's arguments merit is an eye roll and a swift denial, and not this kind of, belabored one-day hearing and the like. And every time she has these hearings, it delays the day of reckoning for Donald Trump, which is all he wants, because if he can stretch this past the election, he can order the Justice Department to drop this prosecution.
And Bradley Moss, given the history of the Espionage Act and the use of it in criminal cases, has this ever been raised before, that it's too vague to use in prosecution?
Every single criminal defendant, as far as I know, who's ever been prosecuted under the Espionage Act brings this same motion. They all argue it's unconstitutional, it's too vague, it can't be applied like this, and they all fail. Judges over and over in multiple district courts across the country have always rejected this argument. And what concerns me, and this is kind of following up a bit on what Andrew was saying, is Judge Cannon's failing to meet the moment here. Look, this is going to be one of the most monumental cases she's ever going to handle. There's been a number of cases over the last decade, all tied up with Donald Trump one way or another, where judges have had to put their name in a moment of history and say, here's my view on the law, right or wrong. Here's how I'm assessing it. She keeps punting. She keeps bobbing and weaving, trying to push it off onto somebody else to make the tough choice. She's trying to push off some of this into potentially being a jury issue, making 12 ordinary Americans try to evaluate things that lawyers far smarter than me argue over every single day, and now he's going to stick it onto a jury. This is her job. She's going to have to rule on this as a matter of law, or she's going to be putting way too much burden on this jury.
And Andrew, it never occurred to anyone in a confirmation, a judicial confirmation hearing, to ask the question, will you recuse yourself from criminal cases involving the president who appointed you, because, of course, it's never happened in history. But here we are. And here the country is watching this grotesquerie of a Trump-appointed judge leaning in every way she possibly can in favor of the man who appointed her to her judgeship. The most glaring and poisonous conflict of interest you could ask for in a federal courtroom, because it also contains now this dynamic of her judicial future if Donald Trump were somehow to win the Electoral College again, which is obviously dangling in the air there in its totally obscene way.
So I agree with you that what she is doing and her behavior and the fact that she has been reversed twice for not just sort of making minor errors, but really significant errors, and all of the things that she has done, consistently is one-sided, raises all of the things that you say. But I think there's sort of two victims here. One is the public, which is entitled to a speedy and fair trial here, at which the defendant is accorded due process. But the other is something worth remembering, which is there are judges appointed by Donald Trump who are really good judges who take their oaths seriously. There are judges appointed by Republican presidents who rule against Republicans. There are judges appointed by Democrats who rule against Democrats. Why? Because they act on principle. And so one of the things that she has done is made it, unfortunately, extremely relevant to ask that question of who appointed you, because it's hard to see any other explanation for the way that she has behaved, even with trying to think of, well, is it just inexperience? And I think that she has shown over and over again that that is not a consistent explanation for how she is behaving in the way she is handling this case.
Yeah, and Neal, we all remember, well, some of us remember, the most important Supreme Court case involving a president of the United States, which involved criminal behavior, was Richard Nixon, and it was a unanimous Supreme Court opinion ordering him to turn over those tapes, which ultimately ended his presidency, and for which he needed a pardon after leaving the presidency so that he wouldn't be prosecuted. And at least four of those judges, I believe it was three of them at least, were appointed by Richard Nixon. And at the time, no one had an issue with that. No one's faith was shaken in the possibility that judges appointed by Nixon would be deciding Nixon's fate. But this point in the 21st century is another world.
Yeah, I think you're exactly right to think about Nixon, because there, I think there was a concern that the three Nixon appointees would side with Nixon just out of loyalty, and they didn't. I think only Justice Rehnquist did at that time. And, that is something, I want to pick up on something Andrew said. That is the historic role of the federal judiciary. I had the privilege of clerking for Justice Stephen Breyer the year after he was nominated to the Supreme Court by Bill Clinton. And we had the Paula Jones case, and he ruled against Bill Clinton on the Paula Jones case, despite all of the politics and all of the pressure and the like. I remember when the Affordable Care Act was being argued, and it was Chief Justice Roberts who cast the deciding vote to save Obamacare, obviously handing a huge victory to Barack Obama right before the 2012 election. That's what judges do. And by the way, Lawrence, that's what the Court of Appeals did to Judge Cannon. It was three Republican appointees who reversed Judge Cannon twice last year in stark language, including a Trump appointee. So, this is the way the federal judiciary is supposed to operate. And my, deep, deep hope is that that can still happen here.
Yeah, and this is going to be one of those rare moments. Everybody should record it. It should go to the Museum of Broadcasting. I'm going to not correct Neal Katyal on a Supreme Court matter. I'm going to add a footnote to the reference to Justice Rehnquist. He recused himself from the Nixon case, so it was an 8-0 unanimous decision. But there was nothing that would indicate that if he hadn't recused himself, he wouldn't have joined that majority. And And Bradley, that point of Rehnquist's recusal, it makes it. It kind of goes to making my point here about Cannon and why she absolutely is someone who should have recused herself, and even recognizing her own complete lack of experience and an ability to handle a case like this.
Yeah, it really makes you wonder how she's going to handle these other motions that are still pending that she's dragging her feet on. You know, leading up into the segment tonight, you know, Andrew and I were joking about various Yiddish terms to refer to some of these things. I look at some of these pretrial motions that Donald Trump has filed, especially with the Presidential Records Act, which was up today in this hearing. It's a schmagegi. It's nonsense. There's no possible realistic idea that this could possibly ever be viable. But she gave it this full day hearing, and we still don't have a ruling on it. And that becomes the concern, whether it's, you know, simply inexperience, you know, whether it's bias, or whether she's just not meeting the moment. She's not addressing this in the manner in which she should as a U.S. District Court judge, and she's not putting meat on the bones for these rulings. Stop kicking the can down the road. Make a decision. Put your name on it and let the chips fall where they may.